and the prosecutor's office, as well as myself, have phone records that is proof that I was actually innocent of that crime and that a police report was falsely admitted. I had contacted the Attorney General, Dana Nuss, about this because there's a page in 33 of my transcripts that reflect fraud upon the court. And when a fraud
Mr. Milhan, could I interrupt for just a second?
Really, excuse me. Now, this is my issue. Now, that case.
State of Michigan versus Glenn Milhan, case number 23 FB 1548.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Glenn Milhan. Could you state your name for the record, Glenn?
My name is Glenn Milhan.
Thank you. Good morning, sir. All right, we're here for sentencing in this matter. Have you had a chance to review this report with your client?
I did, Your Honor. We went over it together.
All right. Any corrections, additions, or deletions to the report?
No, Your Honor. We would ask the court follow the recommendation from probation with just one caveat. Mr. Milhan did indicate to me that he would like to be able to use marijuana, and he doesn't currently have a medical card. So I did advise him we may have to submit a little more information. Well, he may have to get the card first, and then we might have to submit a letter. He did tell me that he uses it mostly for appetite. He has a lot of issues with that, being able to eat. So without using medical marijuana for that purpose, he would require other medication. As far as I know, he's on different medications for his mental health. And I think there's often could be, issues with taking those different medications. And he's had really some adverse symptoms. He said using marijuana has been the one thing that really has helped him with his appetite without feeling, over medicated. So that would be our only request. But other than that, we would ask the court follow the recommendation from probation.
Ms. McDuffie?
Your Honor, I don't have any issues with the recommendation. I'm just really concerned overall about Mr. Milhan, this case, his history. I don't have a good sense of, I guess I should say, where he is and what's really going on and what it's going to take to make some progress here. I was just looking at his last probation, which wasn't very long ago. I think he was discharged from that just in December. So that was also a reduced aggravated stalking charge. So this is behavior that's clearly not being curbed. And of course, we want him to comply with CMH and any sort of, orders and meds that he needs to be on. But I don't know what is necessary to actually get behavior change here. I don't know what's been tried and what has or hasn't worked. I don't know where he's been. I just don't know. So I'm just a little bit at a loss for what needs to happen with him.
Thank you. Mr. Milhan, it is your opportunity to say what you would like to say to me. I want you to know that I reviewed this report very closely. I took a look at the text messages, and I guess you call them text messages that you were sending to this individual, as well as the threats to her father and her family and exes. I'm extremely concerned. I also, took a look at the behavior exhibited towards CMH, which is outlined in the police report. And I share the concerns that the prosecutor shares about the best way to try to get you stabilized and to keep this behavior from continuing. I also reviewed that you have concerns about always being on probation. And, the bigger concern, obviously, is the behavior that gets you here, Mr. Milhan. So what would you like to say?
There's two issues I would like to address. The first being that the complaining witness came to court and got on the stand and told the judge she wanted me out and that she wanted me out. She was not wishing to testify. Now, if I had pursued it, the charges would have ended up getting dismissed for witness unavailable because she was not wanting to testify. I took the plea bargain to get out of jail due to my last case, which I was in jail for 15 months and still at the pretrial status. And the prosecutor's office, as well as myself, have phone records that is proof that I was actually innocent of that crime and that a police report was falsely admitted. I had contacted the Attorney General, Dana Nessel, about this because there's a page in 33 of my transcripts that reflect fraud upon the court. And when a fraud
Mr. Milhan, could I interrupt for just a second?
Speaking freely, excuse me. Now, this is my issue. Now, that case continuously got brought up. In this case, if it turns out to be a void sentence, which is going to be, this is going to affect this case because I've already been prejudiced. Since it's being used against me, if it turns out it's void, then all the decisions in this case has been void as well.
All right, I'm not going to proceed with sentencing today. I need to hear from the mental health department as to what is going on with Mr. Milhan. He is clearly still not stable, and I'm very concerned.
I am very stable, Your Honor. I'm not out here causing any problems at all. I'm doing everything.
You were causing problems, sir. That's why you're here.
Yeah, but I've been on bond and I have not caused any problems. I have demonstrated good behavior. I showed up to court. I did everything that they asked me to do.
I'm not revoking your bond. I'm requesting that someone from CMH come and give me a report. And that's what I'm going to do, sir.
All right, what do you need me to do, Your Honor?
All right, sentencing in this case is going to be adjourned until March 11th.
I challenge the court's jurisdiction. I feel that authority is being overstepped, and I feel like the court has lost jurisdiction of me.
At 10 o'clock a.m., sir, you're treading on thin ice here, so I would suggest that you stop talking. Okay? March 11th at 10 o'clock a.m. I'm going to do this on Zoom still with someone from CMH present so I can make a determination as to what is the best sentence here, because I'm very concerned about Mr. Milhan. He does not understand the gravity of this situation. He does not understand the nature of the court proceedings. And I'm not sure that a probation sentence is the best sentence. I'm not sure that we're fully protected from Mr. Milhan, to be honest. So I'm going to adjourn this to March 11th at 10 o'clock a.m. on Zoom still. But is this Ms. Johnson's case? All right. I'm going to ask Ms. Johnson to have someone from CMH either provide me with a report and an update or come to court to do so via Zoom. I see your March 11th, sir, at 10 o'clock a.m., okay? Thank you.
Court does call the case of the people of the state of Michigan versus Glenn Milhan.
Good afternoon, Your Honor. Nicole Hughes on behalf of the people.
I'm the Water Assistant Public Defender on behalf of Mr. Milhan.
All right, I have before me a plea form that indicates that the defendant, that's what we're doing today, would be pleading guilty to, or no contest to the charge of stalking the 1-year offense. Upon his successful plea to that charge, count one, the aggravated stalking, would be dismissed. There's also an agreement that there would be no delays or deferreds and must comply with community mental health treatment. That is the court's full understanding of the agreement.
As the people's understanding, there will also be requests for your honor to both sides regarding the no contact order at a later.
Pardon?
We'll both want to talk about the no contact order with you at a later point.
Okay, all right. Very good. Is that a correct statement of the agreement?
That is correct, Your Honor. It would also, pending sentencing, be a condition of his bond that he comply with CMH as well as ultimately a condition of probation.
Pending sentencing.
Yes.
All right, very good. Milhan, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name for the record. All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of stalking. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and also up to 5 years probation. You understand that, sir?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Two things about a no contest plea. You have to make sure that you understand it. First of all, it means that you're not desirous or wanting to contest this charge. You understand that?
Yes.
Second thing that you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that? You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, do you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? This form here.
That's the second form you signed.
Any question regarding any of those rights? You're not at the podium, but if you could look at paragraph 5, could we give them a copy? Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
Just that I would be released today. Other than what's been put on the record.
Okay, I guess I better make sure. I'm not clear what counsel has talked about and about what you may think I've agreed to do, or what issues are regarding release. I need you to understand, sir, there's been no discussion with the court regarding your release today. I may hear argument on that, but I need you to understand that.
Your Honor, may counsel approach?
Sure.
Yeah.
Okay, I guess so that the record is clear and so that you understand, Mr. Cohen, and counsel's explained it to me. While the court hasn't necessarily agreed, I now understand what counsel's indicating. And that is it's really your engagement with community mental health that would lead as a condition of your release. And they had mentioned that in terms of the plea agreement. So I get what's going on. While I'm not agreeing to it, what counsel has indicated to me will certainly lead me in that direction. You understand that, sir?
To a certain extent. Now, I don't fully understand. I'm not gonna lie.
Oh, no, don't. I mean, if you don't understand, I'll try to explain it another way. Here's what I understand. I understand that your release or the agreement to release, they both have indicated, both counsel have indicated that was part of the agreement that just wasn't placed on the record, is conditioned upon your engaging with community mental health. You follow me so far?
That be as a condition of release.
Say again?
As a condition of release.
Yes, that you'll be engaging with community mental health. When we were up here at the bench, and I usually don't discuss bench conferences, but I'll tell you what I asked, because your attorney went back to ask you. I wanted to know if while you were in custody, you had been engaging or had been connecting with community mental health.
Yes.
And so that's the answer he gave me, that you had been. When I say that leads me in that direction, that's the kind of thing I want to make sure that is happening, so that if you're out, it's just a continuation of the engaging in that process. The opposite of that would be, and where I wouldn't do it right away, is to say, I'm going to release you and you need to just go over to community mental health, but you don't really have a connect. You follow me? So that then you walk out the door and we don't see you.
Yeah, I'm on, back on my medication, and I've been in frequent contact with mental health.
Okay, so you're back on the medication and there's a, we'll talk about it a little bit more, but there's a plan in place for you in terms of your medication and other types of things, right? Okay, so that's what was discussed up here, and is what council had indicated, so that you know, okay? All right, understanding all of that, and I know it's a little bit convoluted and whatever. Do you still wish to continue your plea of no contest?
Yeah, I just wanted to make sure, I would be released today.
I'll say this, based upon what I know right now, yes. All right, I may have a few more questions. If I were to head in the other direction for whatever reason, I don't think that I would, then I'd allow you to withdraw your plea if that's what it came down to. Got it?
No contest.
All right. Has anybody threatened you or coerced you in any manner to get you to plead?
No, sir.
You're doing this voluntarily and of your own free will? All right. Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 23-92139. Any objection to the court having reviewed that report?
No objection, Your Honor, and for the record, the basis for the no contest plea is in light.
Thank you, sir. All right, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 5th at 10 a.m. before Judge Washington.
February 5th, 2024, 10 a.m. before Judge Washington. All right, as to Bob in this case.
And for the agreement that was reached, I'd be asking the court to release Mr. Milhan on a personal recognizance bond pending sentencing. He does have an apartment in Ypsilanti, which I believe he can still reside at. The condition obviously is that he'll continue to engage in community mental health and continue to take his medication as prescribed. He's agreed to that condition as well. It's also my understanding, having spoken to Ms. Hughes, that the complaining witness in this matter does wish to have contact with Mr. Milhan, that she is a support for him and she helps him get to his mental health treatment appointments. There does not appear to be a history of violence between the two of them. In our discussions, Ms. Hughes and I agreed that there does not appear to be any imminent threat or anything like that. So we'd be asking that he be allowed to have contact with her as long as it's not unwanted contact.
Anything from the people?
Yes, Your Honor, thank you. I met with this coroner prior to coming into the courtroom today, as well as with the victim's rights advocate. Ms. Warner very much wanted the defendant released from custody, and the motivation seemed a little bit different than what I've seen sometimes in domestic violence situations. Her motivation very much was his mental health. That she believes that him being out in the community and working with community mental health and making sure that he is on the right medication, right dosage is what he needs to stabilize. I expressed to her that my motivations were a little bit different, that I had great concern about her safety. In part of that, I did inquire about their history. I don't want to necessarily put everything on the record that she told me, but I was in a position where I have concerns about her safety. I told her that if the decision was mine on what the request would be today, I would just be saying to her, no contact. I don't want to talk about that. But that's not my job. My job is to be a voice for her as well. And the decision is yours, Your Honor. So she is requesting no unwanted contact. I've explained to her what I understand that to mean, that it puts her in the position of power, it puts her in the position of having control. That if he ever made her feel uncomfortable or unsafe, or if she just didn't want to have contact from him anymore, she would have the authority to say no more contact. She would then be in violation if he did not adhere to that. So there are certainly safety concerns here, but when I talked with her about safety concerns and issues, I would see she brought the conversation back to his mental health, and not in a way to avoid my question, but because that was the answer to the question, was to stabilize his mental health. So for that reason, I am requesting the no unwanted contact, and I am not objecting to him being released from custody.
All right, is she here?
Yes.
Ma'am? Hello. Can you come up? You're not in any trouble. I'm just...
I know, it just takes me a second. I got a pinched nerve.
Okay. What's your name?
Jennifer Warner.
All right. Why don't you, I hear from attorneys whenever they want these changed, but I always like hearing from the person themselves. So you tell me anything you want me to know, but also why you would like to have the no contact provision lifted.
Like I said, I'm trying to just help him and maintain his mental care and to help support him.
Okay. And so you see that as the fundamental issue, his mental health?
Yes.
Okay. And if I were to release him, you don't have any fear or anything along those lines regarding yourself?
No.
All right. And one of the things that the prosecutor brought up, and that it was just the issue of control. You do understand that if I release him, it's not going to be just carte blanche. He can have contact with you. It's no non-consensual contact, meaning exactly what the prosecutor was indicating. You don't want to have contact for whatever reason, any fear enters, or he doesn't keep with his mental health treatment, and you see that happening, that you have the ability to cut off communication.
Okay.
You understand that?
Yes.
All right. So is that really what you want me to do?
Yes, please.
All right. Thank you, ma'am.
Thank you.
Do with the defendant's bond. And sir, you understand what I just indicated regarding the no non-consensual contact?
I'm listening very carefully.
All right. So I need you to understand, more importantly, because you're the one that will be under the jurisdiction of the court, that if she doesn't want to have any contact with you, you've got to cease contact. You don't get to ask why. You just have to cease contact. You understand that? And that it's her decision alone. Follow me? What I will do is I'll reduce the defendant's bond to a $10,000 personal recognizance bond. I will release, or I will delete the no contact provision. In this case, I will add a provision of no non-consensual contact. Should I write that out? This bond is conditioned upon your continued engagement with community mental health, and you are to follow the plan and take all medications as directed. You understand that, sir?
Yes, sir. I just want to make sure, because when I left last time I was incarcerated, they didn't send me on my medication. I just want to make sure I'm on medication. I would like to continue taking it.
Okay, let me ask this. How often do you take your medication? Every day? Did you have medication when you came in?
They should have some probably in healthcare.
Pardon?
They should have some for me in healthcare.
In healthcare, you mean down in jail?
Yeah.
Well, all right, let me ask you this. Let's say they release you and they don't give you any medication. What are you going to do?
Contact mental health.
Okay. Do you know how that,
Clinton's property.
oh, so that he'll have someone all right.
Judge, I just sent an email to Ms. Stewart, Sarah Stewart, asking to if she can make sure that he's got a couple days worth of medication upon his release.
Okay,
I'll let her know he'd be being released today.
all right. That help you out?
Yes, sir, thank you.
All right.
If you
Okay.
don't have it, then just go to CMH first.
Yeah, get yourself there. I'm encouraged that if it doesn't happen, you know what you gotta do. Okay, all right. Anything further?
Nothing from the defense, Judge.
Nothing? All right. Good luck to you, sir.
Thank you.
Bye.